Hello everyone, welcome to a new episode of Immigration Fridays. I am your host Prashanthi Reddy and we're here again to explore the ever-evolving landscape of US immigration. So what's on the agenda this week? This week started off like a roller coaster because the new USCIS regulations on H1B were announced yesterday. And this regulation will impact the very future of the H1B program. So let's discuss about this further. So as I said, the US Department of Homeland Security released a final rule yesterday, December 17th, introducing significant changes to the H1B program. This is the first major H1B regulation to come out in a long time. There have been quick fixes, but nothing as comprehensive as this H1B regulation that came out yesterday. We were expecting this for a while because the regulation was published and there was a comment period, but we were not sure with reference to the timing of when the final regulation will be announced and then when it will come into effect and what would be the content of the final regulation, after the comments, etc. So now we know after 30 days, starting yesterday, the final regulation will come into effect. So that will be on January 17th, just before Trump's second presidential term begins. And this is not a coincidence. This was intended because the present government wanted to make it difficult for the Trump government to make further changes to the H1B program. Now that there's a final regulation in place, it's difficult for any future government to make additional changes to the existing regulation. So that was the whole purpose of finalizing the regulation and making it active before the new government came in. So now let's discuss, let's summarize the H1B regulation. It is many pages, many hundred pages long. So we can't go through every detail, but let's do a quick summary of the changes. And some changes are expected. It's more of what they did in the past, just trying to regulate them. Some changes are intended to make things more clearer. Some changes actually will make a significant difference or have an impact on the H1B program. So let's go through. We have 9 changes actually. So let's go through each one. First one, the deference policy. USCIS will continue to apply a deference policy. That is, if they have previously approved a H1 and if you're filing a transfer or an amendment or an extension and there are no material changes, then they will not send an RFE asking for the same documentation again. So this deference policy has always been in place as a practice, but sometimes it is practiced by officers, sometimes it isn't. So they put it in the regulation so that it will be adhered to every time you file a H1. Second, they've updated the definition of specialty occupation. This was in the proposed regulation as well, but they changed from the proposed regulation, they changed it a little bit. So they've broadened the definition of specialty occupation. So this is a significant change. And they've included a range of degree fields, as long as they are directly related to the job duties. So just to go back a little bit, what is a specialty occupation? The definition is any job that requires a bachelor's degree in a specific field is a specialty occupation. So instead of saying specific field, they have broadened that to a range of degree fields as long as those fields are related. So previously, in order to qualify for a H1, the Occupational Outlook Handbook, which is where USCIS goes to, it's a Department of Labor publication, it's available online. That's where USCIS usually goes to see whether a particular position is a specialty occupation or not. So in that Occupational Outlook Handbook, that's one of the sources, but if the job is not in that source, then we can go to other internet sources. So in the handbook, if it says that a particular job, for example, the job of a systems analyst, if the OOH says that the position, the industry generally requires a bachelor's degree in engineering, physics, math, computer science. So that's a range of degrees, right? So presently USCIS would not approve such a case because they want it to be a specific degree. Now they're saying the range of degrees is fine as long as the degrees are related to the job. So every single degree that you're asking for should be related. So if you're saying math, then you have to show how math is related. If you're saying computer science, you have to show how computer science is related. So as long as it's a related field, it's number fine. 3. They've expanded the definition of CAP exempt employers, especially for non-profit research organizations and governmental research organizations. So they've replaced the term primarily engaged in research activity to research activity should be a fundamental activity. From this, basically they don't require that the employer should only be engaged in research. They can be engaged in other activities as well, but their fundamental activity has to be research. So some organizations which do research but do other activities as well, they would qualify then now as a CAP exempt employer. Bona fide position requirement, that's number 4. What does that mean? So H1B petitioners must now provide evidence that the offered position is a legitimate specialty occupation role. So you have to basically show that there is a specialty occupation job available by the employer. So the job cannot be speculative, but they're not using the word speculative anymore. So after 2020, USCIS has been approving cases without work orders and contracts. This is especially with reference to the consulting companies. In the consulting company scenario, previously USCIS used to ask for work orders and contract to show that the job is not speculative. Now they're not, because there was a ITServe versus Cessna lawsuit in which ITServe won, and after that, since 2020, they have not been asking for contracts. Now they have legitimized that, they have put it in the regulation. They can again ask for work orders and contracts in the consulting scenario. And this is again a big change, which will make filing of a H1 by consulting companies harder. Even for a non-consulting situation, they can ask for the company to show that they have enough specialty occupation work. So if you're filing as a software engineer and you're not a consulting company, you're an in-house, maybe product development company, you have to show the contracts that you have with to sell your product, for example. You can show your tax returns to show, your business revenues. You can show contracts to show volume of business. So that's what they're looking at. That's bona fide position requirement. Number 5, they have codified their site visits. USCIS has always performed site visits through their independent consultants. They're called FDNS visits. Previously, it was not required that you entertain an FDNS officer, but of course in practice, if you didn't, then they could just revoke the H1B petition. But now they've put it in the regulations, so they have the right to deny or revoke a petition if the petitioner refuses to cooperate with the site visits. So they've put it in the regulation and given it more credibility. In addition to that, number 6, third-party staffing requirements. In addition to the contract requirements that I just spoke about, for H1B workers assigned at a third-party position or third-party client, the requirements at the third-party site will determine whether it's a specialty occupation or not. So depending on what the end client requirements are, if the end client requires a bachelor's degree in computer science, then it will be a specialty occupation. So it does not matter what the employer requires. So you would need a letter from the end client or proof of their job description online to show that a bachelor's degree is required for a particular position. Number 7, this is very, very important because it's completely new, self-sponsoring for H1B owners. So the rules allow certain owners of petitioning entities to self-sponsor. What does this mean? This means that if you don't have a company and you are owner of the company, even if you own majority share of the company, you can petition a H1B through that company for yourself. Of course, these kind of H1B petitions are capped at 18 months. So you get an 18-month H1B, then you get an extension for 18 months, and then after that you would get the full term of the H1B. So they're capping it in the beginning to ensure that there is no fraud. And this is huge. The fact that you don't need another employer to sponsor you, and you can sponsor yourself through your own company. They have also said that even if you're performing some of the management jobs, which you would, right, as the CEO or part owner of the company, even if you're participating in the management of the company, as long as you're also doing specialty occupation work more than 50% of the time, then you will still qualify under this self-sponsoring H1B category. Remember, this is a final rule. So folks out there, you can try it out. Try sponsoring yourself after January 17th. Very, very important for entrepreneurs and very useful for them. Number 8, USCIS has said maintenance of status documents have to be included with every petition. So this means that they're going to be more stringent on maintenance of status. They want to make sure if you're filing an extension that you maintained your status in your previous H1B term. They might ask for pay stubs for all the years, W-2s, proof of work. So this is a cumbersome requirement, and we might have to submit much more documentation for H1B extensions and transfers and amendments when compared to previously. Previously, they would ask in an RFE in some cases, but not in very few cases, not in all cases. Now they're saying that in every case you have to show maintenance documents. And finally, number 9, the cap-gap rule has been revised for F1 students. F1 students, the cap-gap rule was terminated on October 1st, but now you can continue to use your cap-gap status until April 1st of the following year, which means that in 99% of the time, students will never have to file a H1B, F1 extension because their H1 was delayed. This is so very, very important for F1 students. So just quickly about how is this going to impact various scenarios. Let's look into that. How would it impact the status of existing H1B visa holders? If you're presently on a H1, it'll only impact you if you're going to file an extension, transfer, or amendment after January 17th. So then you'll have to follow the new regulations with reference to the definition of specialty occupation. So maybe previously you qualified and maybe you won't now, or maybe you didn't qualify for a certain position, so now you can change to a different position. You can qualify maybe for a cap exempt employer based on the more expanded definition of who is a cap exempt employer. If you are working for a consulting company, it's significantly going to change your extension or transfer process because now you require contracts and work orders. You require to look at the what the requirements are for the end client rather than your employer. So this, and you also have to file more maintenance of status documents. So it's going to make it in some ways harder, in some ways more difficult for you if you're already on a H1. Also, for students, how is it going to affect students? And we already discussed that. It's really advantageous for students and in the context of the H1B cap because now their cap status extends until April 1st of the following year. So no matter what the delay in the H1, most probably they will not have to file for a F1 extension. How does it impact them otherwise? Then you have to go through everything again. Maintenance of status documentation has to be provided for an F1. Third-party staffing requirements for if you're filing through a consulting company. etc., etc. So everything impacts you. Some ways negative, and some ways there might be a positive impact as well. On the whole, is this a good regulation for employers on the whole? Or is it there's more bad things than good things? So it's a mixed bag. While they've increased the definition, they've expanded the scope of who can apply. They've done some good things, like also difference policy that they've used. The F1 thing is a good thing, but and some other things like site visits, etc., were already there. But they've included some things such as contracts and work orders at the end client site, and getting end client letters to show what is their requirement. So this was there prior to 2020, so it's not a surprise, and I would say it's just back to what it was in 2020 prior to that. So I would say that it's not a big change. It was expected, and we just have to live with it, and it's to be expected. So, but the huge change I would see, which was never, is basically self-sponsoring of H1Bs. This was never the case. There was never a rule. Or there was a rule, but it was never self-sponsored. H1B owners were never allowed to file H1s through their own company. So this is a sea change, and it's a positive change for a lot of entrepreneurs. It depends on who you are and how you look at it. If you're a consulting company, maybe it's not a good change for you, because then your consultants could most probably file their own H1 if they have their own company. So it depends on what perspective you're looking at. It could be a good thing or it could be a bad thing. How do you stay prepared? The same way, make sure you have complete knowledge of what this H1B new rule is. Read the entire regulation. Contact your attorney to find out if it applies to you or how it applies to you. Always keep yourself updated with reference to what the law is. And with that, it's a wrap of our Immigration Fridays video. Immigration laws, as you know, can be very complex. So if you need any legal help with the new policy, our team is here to guide you and to help you. Please feel free to drop us an email, prashanti@readyesq.com, or call us 212-354-1010. Hello everyone, I am so excited to share that we have hit 1,000 subscriptions on YouTube. A huge thank you to each and every one of you for your support. It means so much to me. This is just the beginning. I can't wait to bring you more immigration news, tips and updates, and keep growing together. If you haven't subscribed yet, now's the perfect time to join the journey. Thanks again, and I'll see you in the next video.